Hi everyone, my name is John Naselli. I'm an immigration attorney for over 43 years, and I'd like to bring attention to a big issue that's affecting many people. So if you're currently in court proceedings and you have a U visa approved, when you go to court, the immigration judges basically are no longer giving adjournments in order for that U visa to become current and a green card to be available for you. So U visa, for those who don't know, are visas that were granted to people who've been victims of crimes. So the way it works is you get the police report, you file with usually with the law enforcement office, probably the district attorney's office or U.S. attorney's office. If it's a federal case, they basically sign off on a report that you are a victim of a crime, you do meet the eligibility requirements for a U visa, and then once you have that, you send it to immigration. Immigration then approves it, and you have to wait until the visa becomes available. So that visa could take, up to even 10 years to be available. The problem is when you go to court and you tell the judge, well, judge, listen, I filed my case, it's already been approved, and I just need more time. The judge will say, well, it's not the court's problem because the BIA which is the Board of Immigration Appeals, has ruled that if the visa is not going to be available in what they consider to be a timely fashion, and 15 years is certainly not timely, or 10 years, so as a result, they will not give you an adjournment. And then what happens? You end up getting deported, have to appeal, and when you appeal the decision, most often the Board of Immigration Appeals will get that case and say, oh, sorry, well, it's not available, so we agree with the judge. So you're basically out of luck and you get deported. So that's the gratitude that you receive for being a victim of a crime and applying for a benefit that's available to you. There was a recent case as of yesterday or the day before, which is a similar situation for special immigrant juveniles. So if you're a special immigrant juvenile, you basically are found to be eligible by a family court in whatever state you live in. And then once you have that family court order that a guardian has been appointed to take care of you, basically, then you file with immigration and you file a form I-360 and the document gets approved. Again, that visa is not available all the time readily. So you may have to wait some time, maybe 2 or 3 years. You'll go to court and the judge will say, well, sorry, the visa is not available in a really reasonable time, so we have no choice but to deny the case. So in the same process, you appeal, the appeal gets denied, and now you have an order of deportation. So the purpose of the program is being totally circumvented because in that particular case, most of the people are minors. They all